Yes, hello everyone, and really it's a pleasure for Barry and I to welcome you today to this event. Barry will be introducing it in further detail, but I just wanted to introduce you really firstly on behalf of the European Society of International Law interest group on international criminal justice. So basically this event is under the auspices of that interest group, and Barry and I very much encourage you to reach out to either of us if you're interested in being more involved in the interest group. Obviously by the name of it, it's obvious that it's attached to the European Society of International Law, and essentially it's a relatively new group. There are a number of different interest groups within the European Society, and there wasn't one on international criminal law. And so it was only set up a bit over a year ago, and it's coordinated by 6 different individuals at any one time. And Barry and I are leading it for this year, and basically it just provides a great space to share ideas, to network, to build some scholarly connections, as what we're doing today. So we're going to be having probably 2 more events for the remainder of the year. I will somehow work out how to send you information about our next event. But basically right now we have a call for papers that we'd love you all to be part of if you're interested. So basically each year the European Society of International Law, without COVID interrupting, tends to meet, and before the main meeting, the interest groups have the chance to hold their own workshops. And so we're going to be doing that this year for the interest group on international criminal justice. And we're going to be thinking through the notion of basically the relationship between international criminal law and transnational advocacy. And we're trying to think through, whether or not it's a good thing essentially for international criminal law to be turning its sights and interests into new and diverse areas of global governance. And so we put out a call for papers, and basically the call's open until the 25th of April. The event, I will double check the date for the event. Sorry, let me tell you when the event is. Well, the annual conference is the 1st to the 3rd of September. So the event itself is the day before, the 31st of August. So basically we'd love to receive your abstracts of 300 words by the 25th of this month, if you're at all interested. And please do email Barry or I can put our email addresses in the chat if you'd like to hear any more details. But I don't want to take away from today's event, and it'll be great to hear more from our speakers soon. So over to you, Barry. Thanks very much.
Thanks, Michelle. First of all, thank you everyone for turning up and joining us today. It's always a privilege. And what is today's event about? Well, interdisciplinarity and international criminal justice. This is actually the 2nd roundtable that we've sort of convened. We had the idea of convening roundtables around new monographs, collections of new monographs in the field of international criminal justice. So we had one last year, and this is our 2nd. And we thought this time we'd do something on interdisciplinarity, because it seems that, international criminal justice, a field constantly in crisis, but one area where it does not appear to be in crisis is, in the kind of sheer breadth and depth of scholarship that is being produced in this field from, a rich array of disciplines ranging from law, criminology, anthropology, political science, sociology, etc. And, interdisciplinarity, bringing disciplines together, so to speak, seems to be a term that gets, used a lot, but is, not necessarily well understood, not actually deconstructed and talked about and reflected upon, despite its use. And so what we thought we'd do is we'd gather together a couple of leading scholars in the field who have produced exciting new monographs, which may potentially be described as having an interdisciplinary frame, although I'll allow the speakers to self-define how they see themselves in relation to that term. And so that's what today is all about, really thinking through interdisciplinarity and international criminal justice. And I should say at the outset, unfortunately, Professor Kirsty Loan has had to cancel her participation due to personal circumstances, so she will not be able to join us today. But we still have two wonderful scholars who will be joining us to talk about their books, and a wonderful chair who I'll be introducing now, Professor Heidi Matthews, who's an assistant professor at Osgood Hall Law School, where she researches and teaches in the areas of international criminal law, the law of war, international legal history, political theory, domestic criminal law, and the legal regulation of sex and sexuality. Her work theorizes contemporary shifts in the practice and discourse of the global legal regulation of political violence, with particular attention to gender and coloniality. So it's my privilege really to now hand the floor to Heidi to take this forward. Thank you, Heidi.
Thanks so much, Barry and Michelle, and Henry and Umara as well. It's wonderful to meet both of you for the first time in this virtual space, and to have the opportunity to engage with your work, and to do that in what I think is going to be a relatively informal setting, a pretty intimate context, as intimate as all of our black boxes can be. And that's not an admonition since you're not students. And I should say at the outset, I'm just getting over COVID, as is my 1-year-old twins and partner. And so I might be operating at kind of half speed, or with residual brain fog, and I see from the chat that many of you are going through it as well, or probably have just gotten over it. So solidarity to everybody here from that perspective as well. So I'll just say initially, thanks for inviting me to be here. This is tremendous. I will kind of just read out, if that's all right, the abstract for the event to kind of get us all substantively on the same page. And then I'll briefly introduce the two scholars whose work is being featured in this event, and then briefly describe what I've already said will be a pretty informal format, I think. So this is the description of the event, and I think the PDF has probably been shared in the chat as well for folks, but this might be helpful. So the event abstract reads as follows. The field of international criminal justice is situated at the confluence of multiple coexisting, competing, and cross-fertilizing regimes. Normatively, the field is host to a plurality of actors and institutions informed by diverse traditions, influenced by varied interpretive methodologies, and often in dialogue with other interrelated and overlapping domains, including the field of human rights and transitional justice. And factually, the field examines a plurality of mass atrocity situations, each distinct in terms of their location, participants, size, and scope. And analytically, the field has been examined and scrutinized from a range of perspectives, spanning disciplines as diverse as law, criminology, anthropology, political science, sociology, psychology, history, and philosophy, and probably many others, each seeking to understand particular dimensions of its origins, rationales, meanings, and effects. And so this roundtable then seeks to examine interdisciplinarity in the field of international criminal justice. Interdisciplinarity has been characterized as difficult, if not impossible, particularly if understood as a synthesis of two or more disciplines that produces a novel approach. In practice, this kind of work often does little more than remain grounded in one particular discipline while dabbling in the theory and methods of another. And the roundtable then aims to put into conversation the work of three scholars, sadly now two, who have recently published monographs that engage with the practice of international criminal justice from a range of different disciplinary perspectives. So that's the substantive framework for the event. So before I continue, I want to give just a little bit of a land acknowledgement, which I do whenever I guess I'm in a role like this. And so I want to just briefly acknowledge the territory on which I find myself today, which we now call Newfoundland and Labrador, as the ancestral homelands of the Beothuk people. The island of Newfoundland is also the ancestral homelands of the Mi'kmaq. And I'd also like to recognize the Inuit of Nunatsiavut and Nunatokavut, and the Innu of Nitassinan and their ancestors who are the original people of Labrador. And so I'd encourage everyone attending to take a moment to reflect on how the territory you find yourself on has benefited from myriad relationships of care and stewardship that have sustained the lands. And so now I'm going to introduce briefly the guests for today. So firstly, Umar Ba is an assistant professor of international relations at Cornell University. His research focuses on law, violence, race, humanity, and world orders in international politics. And he's the author of this new book, States of Justice, The Politics of the International Criminal Court, out with Cambridge in 2020. And his publications have also appeared in Millennium, Journal of International Studies, Human Rights Quarterly, the Cambridge Review of International Affairs, International Politics Reviews, African Studies Quarterly, among others. We also have Henry Redwood today, who is senior lecturer in international relations at LSBU. His research focuses on the formation and governance of post-conflict communities, with a specific focus on the use of international courts, archives, and arts-based interventions as peace-building and transitional justice tools, with area specialisms in the former Yugoslavia and Rwanda. He has been awarded numerous Research Council grants, most recently an AHRC-funded project, which is a participatory arts-based project in Bosnia and Herzegovina. And just a heads up, I'm going to ask you about that in the discussion, Henry. He's also published widely, including The Archival Politics of International Courts with Cambridge University Press in 2021, and is co-author of Impact in International Affairs, Rutledge 2021, and co-editor of Reconciliation Histories, Rutledge 2021. And has published in a variety of other outlets as well. And of course, we're here today to focus in particular on the Archival Politics book. So in terms of format, I think what we're going to do is I'm going to invite Henry and Umar to speak for, I guess, roughly 10 minutes on what, generally thinking around interdisciplinarity, what it means to you, what it means to the particular books that we're here to talk about today, and then perhaps also your wider research agenda. And then I think we'll have a little bit of an informal discussion kind of amongst the three of us. But again, this is really meant to be an informal setting. And so I don't want to set up a strange, hard distinction between the Q&A and our discussion. So at any point in time, you can ask a question either by entering it into the chat box or just raising your Zoom virtual hand. And so I'm not sure if we even agreed on an order. So if that's okay, I'll just go with the order I introduced the speakers in. And so Umar, I'll hand the floor over to you. And thank you both for being here and taking the time to generously share your work with all of us.
Thank you, Heidi. Thanks also to Barry for organizing this conversation and inviting us, and good to be with Henry and all of you as well. I usually preface these conversations with a disclaimer that I am not an international lawyer. I'm not a lawyer by training. I didn't go to law school. I'm a political scientist. That's how I was trained, whatever that means. And even within political science, I specialize in international relations. So I come to these questions with the focus specifically on the politics of international law or international justice. So that's what I focus on in my study, not necessarily the law itself, but the politics that sustain international law and the international criminal justice system. And to me, interdisciplinarity starts with an attempt to to be undisciplined, to resist the disciplining that goes into our training, especially in political science, which I'm much more familiar with a question that we are told to look for, the puzzles that we are told to identify and try to solve, and the research questions and the methods that are appropriate to use. So to the extent possible, I try to be undisciplined and resist that disciplining, knowing that that in itself has a lot of pushback, and then there's some dangers even in trying to go beyond the appropriate questions or methods that we are trained to use in our own disciplines. So in my work, I have tried to look at the politics of international justice, and my first major work was to look at the ICC specifically. I tried to draw from international law, from history, from international relations, but also comparative politics, trying to do case studies that focused on 4 different African countries. In terms of methods, I've done field work, traveled to these places, conducted interviews with the people who have been affected by the ICC intervention, people who've been affected by the conflicts in these areas. I've tried to do some observation, traveling to the ICC, watching actually the court operate and sitting in the courtroom, in the gallery, and see how that works. More recently, I have started to look at a broader picture of how the international criminal law and how the international justice system came to be. So I've been doing more of archival research combined with a historical IR that tries to look into a revisionist historiography of the international justice system by writing Africa in the picture, by looking at African agency and African proposals in the 1970s and 80s specifically. Overall, what links all this work that I do is the critique. So I situate myself within critical IR and post-colonial theory, and I use the critique itself as a departing point with the scholarship that I try to do. So I'll just stop there for now. Thank you.
Great, thanks, Umar. Henry, over to you.
Thanks. Yeah, and thanks again to Heidi and Barry and Michelle and everyone for inviting me and Omar and Kirsten, who sadly can't join us, to take part in this discussion. And yeah, just to echo Heidi, that would be great to hear. I know seeing some people in the chats that I recognise, I know lots of you have really interesting things to say on this, so it'd be great to hear what you think about interdisciplinarity and international criminal justice as well. So when I was thinking about interdisciplinarity and how my approach to interdisciplinarity informed the book, and I might share some slides in a second as well, just really quickly to help evidence or discuss some of these points. I think the thing that really brought to my attention the value, and I think this particularly of an interdisciplinary approach to international law and international criminal justice, was in my first year of my PhD, I attended a British Law Association conference themed around international law. And as someone that had been trained again, I'll put that in inverted commas, as a historian, and then was now in an IR department in war studies at King's College London. I just found it very peculiar how law was being discussed within this very legal space, how the sort of the black letter law approach was taken as a given, how law was just being discussed as this very technocratic activity, a problem-solving approach to international law. And that sort of peculiarity, I guess, spurred me on to to thinking a number of things about my research project at the time on the International Criminal Tribunal. But I think that's what interdisciplinarity can do when it's done right, is it can be provocative and forces or encourages to think about questions that from one specific discipline may be concealed, or it can render unusual what is taken to be normal and usual within a particular disciplinary space. I'm not so sure that my book is, I think it's interdisciplinary in the sense that it draws on history and post-colonial anthropology, both theoretically and methodologically, and I'm an international relations scholar, if I am anything. But I think that there's a question about whether or not it achieves that true interdisciplinarity, which I think would come from a more mixed method approach than what I adopted in the book, which I've gone on to pursue later with my work that looks more at the use of arts in post-conflict space, which I think perhaps achieves that interdisciplinarity in a way that the book is perhaps more transdisciplinary in the way that it brings different fields of different disciplines into dialogue with each other, rather than necessarily carries across different epistemological and methodological approaches. But we can discuss all of this and where these boundaries lie. But just a couple of, if I can share, just to get into some of this a bit more. So this is, this book that came out relatively recently in September, The Archival Politics of International Courts, takes this transdisciplinary approach to look at, I think, an understudied aspect of international law and international relations, which is archives as sites of empirical research in and of themselves. And I think that's, again, perhaps a starting point to think about the value of this transdisciplinary or interdisciplinary approach, revealing hidden sites of empirical interest within disciplines that might otherwise be ignored. And also on the nod to interdisciplinarity, thank Vladimir Milindinovich for providing the front cover, the artwork for the front cover of the book, which is a replica of a Rwandan ID card. And I've done a lot of work with Vladimir exploring how an aesthetic approach to international relations and methods more generally can help us open up legal archives in ways that other methodological approaches perhaps struggle to, and something we can discuss more in the Q&A. So the book takes the archive, the ICT's archive, which is this sort of huge repository of information as the focus of its analysis. So in this archive, we have, in just the judicial archive alone, we have around 4,000 kilometers of records, 26,000 hours of testimony given by 3,200 witnesses across 6,000 trial days. So this is like this mega record of both, I would argue, the genocide in Rwanda, the 1994 genocide in Rwanda, the development of international law, if we think about the court as situated at this pivotal moment where international criminal justice as a field emerges in the 1990s. But I think more importantly, and this is where we begin to bring together law and politics, it kept on being referred to its creation as this consciousness of mankind. So I think we can also see the material artifact of the archive as this sort of monument to this consciousness. So we can see the archive and the court as being part of the articulation of what an international community may mean in the wake of the Cold War and in the wake of the failure of that community in both Bosnia and Rwanda. And the archive in particular became an increasingly central focus of my research through, and this again, transdisciplinarity, looking at post-structuralist writing, particularly Derrida's work on archive fever, where he traces the etymology and function of the archive to ancient Greece, where the archive is the magistrate's house, and the magistrate is the archivist, right? And through thinking about this relationship between the archive, law, and governance, I think the archive becomes this really interesting site where power, law, and knowledge production all sort of coalesce, and in the process help produce particular understandings of community and govern that community. So again, I think we can see how law and politics and history and memory studies all sort of coalesce or are required in order to understand the political significance of the archive as a site of community making in essence. So these are the questions that essentially underpin the book, around questioning what records of violence are included, excluded from the archive, what systems of power account for this, who controls these narratives. This draws on post-colonial anthropological interest in the role that archives played in constituting the colonial state and the ways in which it was constructed from particular epistemological perspectives to the exclusion and detriment of others, and the ways that this ends up having very violent effects on the communities that are produced as a result. This interest in how politics and law influence each other, and I read Omar's introductory chapter, and there's lots of resonance here in terms of how politics and law influence each other. In terms of this book, what I was interested in doing is breaking away from, I think, what remains a relatively traditional sense of politics and international criminal justice as being about the relationships between states and courts, right? And instead trying to get beneath that to see how politics influences the way in which law is imagined and practiced, and vice versa. So how is law as it is imagined within and practiced within a courtroom political? Like, what is the politics of the very practice of law? And when taken together, this question of, okay, so if this is representative of the consciousness of mankind and helps form communities in particular ways, what is the nature of that community that's brought into being? So this also has draws strongly on the work of Pierre Bourdieu and thinking about the ways in which law is made real through practice, and methodologically also from Foucault and his archaeological methodology. We can speak more about methods in the Q&A, but broadly this was more standard archival research tied with semi-structured interviews, and I also spent some time working as a legal intern at the ICTR on one of their failed outreach projects, shall we say. And these are the three main arguments that result of this around the way that law and politics are co-constituting each other. So we see that how political decisions made outside the court fundamentally shape how law is interpreted within it, and vice versa. This shifting strategy and understanding of justice that evolves across the tribunal's history from a relatively broad understanding of justice framed weakly around a restorative vision of the role of the court to a very legalistic definition of retributive justice. And I argue that this is caused both by a settling of the law, but again, and turning to an interest in the politics of this process because of the interventions of external political actors. And then finally, when looking at the type of community that's rendered through this legal process, unsurprisingly, I think for many, this is one that is fundamentally based on liberal understandings of community, and these sort of liberal ideas and epistemological priorities shape how these records are produced around responsibility and progress, around equality and neutrality and universalism. But underneath this, and this is what I think the archival methodology that I take from Foucault and Bourdieu combined together help us understand, is that beyond this common sense understanding of what international law is, we have a much more illiberal and I think concerning vision of community that's centered around gendered hierarchies, racialized and colonial understandings of community, particularly the subjugation of the subaltern and the exclusion of the subaltern in a meaningful way, and sort of a reification of the possibilities of liberal militarism. And yeah, I've probably already taken up too much time, so I'll stop it there. That's a sort of a snapshot, I guess, of the book and how, I guess, I used different approaches, whether or not it's sociology from Bourdieu or history and Foucault, or an interest in politics and IR to try and unpack what I think is the complexities and hidden politics of these courts and their archives.
Thank you so much for that, both. So a number of different ways in here, and Henry and Umar, I want you both to, and well, Barry and Michelle as well, to feel free to ask one another questions about the work as well. But I wonder whether, so I have both a series of substantive thoughts and then also a series of thoughts that feel more methodological. And then I'm worried about my own brain doing that separation, right? As I'm thinking through your books and also your presentations just now. So maybe I this is a bit, I suppose, not much of a provocation, but an invitation to explore maybe some of the substantive linkages between both of the books around one idea that I think resonates across them as a way to get started. So I'm really interested in this idea of the reification, I think you said, Henry, just now, of liberal militarism and how that happens at the court. But then I wonder if you could say a bit more about that as an archival process, as opposed to simply an institutional or legal process, if that makes sense, right? So how that happens through the creation of the archive. And then I think that concept also comes up in your work, Umar, as well. So one of your key arguments, of course, in the book and key research questions is to ask how actually do non-hegemonic, or what we call weaker states, actually productively engage with the tools and technologies offered by international criminal justice, specifically with the ICC, in order to kind of make their own claims heard. And those claims, as we know, may be good or bad, depending on the politics that you have and the politics that you're coming to the table with. And so I'm wondering if you could reflect a little bit, just based on your findings from your book, about, I guess, kind of the political valence of the commitments that you uncovered in your study.
Henry, you want to go first, or want me to
go? You go.
Okay. So I see a lot of overlap with Henry's work and mine, especially when it comes to looking at what states do in this arena. Because at the end of the day, the constituent members of these international courts are the states, not individuals. In my work, I tried to look at how states that are presumed to be weaker in the international system, meaning states that do not wield the hegemonic power, and I certainly would fit African states in this box. So how do these states imagine ways to engage creatively with the international courts in a way that advances their own political and security interests? That doesn't mean that, of course, African states are abusing the ICC. I think all states, to the extent they can, are abusing international courts for their own political and security interests. But it was interesting to me to look at how African states are able to use the court in creative ways. And creativity here means that using the laws, the norms, in ways that were not anticipated when they were being put in place. And this argument pushes back against the triumphalism of the justice cascade literature, the idea that we are moving towards a world in which accountability has becoming a widely accepted norm, that courts and inquiries and all kinds of legal mechanisms are put in place to advance accountability, which, empirically could be verified if you just account how many courts exist now versus how many courts existed 20 years ago. Then you could draw an easy conclusion that, well, the world has this norm is consolidating. But then looking underneath the surface, you see how it is actually states that in most cases, they are trying to advance their own political and security interests, not necessarily caring much about the norms of accountability. So I'll stop there. Thank you.
It'd be interesting to hear a bit more as well about something I found interesting from the first chapter that you shared was it reminded me a lot of the work on hybridity and peace building literature and the way that international norms are muddied and played with at a local level. And it would be, you started to say some of that about how they're sort of ignored or played with for political interest. But I wonder how there might be some creep into this as well, and how some of the norms slip through even when they're being played with, and vice versa. So in your next round, it would be, if that's not to impose another question, it'd be cool to hear some more on that. But yeah, I think following from that, in terms of this question about liberal militarism, this was in the chapter where I sort of more explicitly unpack what image of community is being produced through the archive. The interest in liberal militarism falls under this, under the analysing how the liberal and Enlightenment logics around progress and responsibility end up concealing the complicity of other actors in the violence in Rwanda and in the international system more broadly. So I think it goes to what Umar was saying around questioning this idea that more law is necessarily better always, because I think when we specifically thinking about the critique here around the way that it reifies, or maybe not directly reifies, but it creates a space in which violence is legitimate, it remains a legitimate part of the international community, is something I think that's a central part of the archive. And this builds on work that others have done, like Elizabeth Dauphiny in her book War Crimes and Crimes of War Crimes and Crimes of War, where it becomes very apparent when you look at the way in which records of violence are produced for the archive and the ICTR, and the way that law is prosecuted, that the purpose of the process is not to eradicate violence and war per se, but it's to regulate it, and through regulating it and delegitimizing some forms of violence, it legitimizes other forms of violence. And so there becomes a question about which types of violence are highlighted here, and which types of actors and their violence are highlighted, and which types of victims of this violence are highlighted and which aren't. And it becomes part of the way in which this very well-known narrative now of the global north, the international as this site of peace, and the international community as the savior, and the local, read in global south as being the site of barbarism and mindless violence. And the ways in which the archive functions reproduces this binary between the sort of peaceful civic international sphere and the dangerous other that is in need of taming, which, you know, is fundamentally at the heart of continuing to legitimize this and other forms of intervention within these polities. And that's, again, not to say what Umar was saying about there is resistance and there is pushback to this imagining, but I think it remains important that the archive becomes a site through which this same trope that's been going for centuries is reproduced in an quite largely uncontested way. And I think what we see as well is that this dynamic increases over the course of the tribunal. So, and we can see this in specific shifts in legal interpretation and jurisprudence, particularly around command responsibility, where over time we have increasingly conservative readings of the law, and we see similar changes in terms of gender jurisprudence. which in essence, when you think through the implications of them, it becomes harder to hold criminal and political commanders to account for the crimes of subordinates, which opens up this space through which violence can potentially take place. So I think that there are political repercussions for this as well. It's not just a purely theoretical argument, and some would argue, like Harhoff, a former appeals judge at the court, that the reason that this shift happens, and to link back to some of Umar's work again, is the influence and role of states that were becoming increasingly concerned that it would be too hard to become, it was becoming too easy to hold senior military commanders to account for crimes of subordinates. So there was a direct way in which, again, politics here influences the way in which law is interpreted. I'll leave my answer there for now.
Thanks both for that. That was a lot going on there, and I won't mention, I guess, okay, so this is not a direct question, but I wonder as well about the, you know, this idea that international criminal courts can, in a way, which I agree with, obviously, right, like launder the violence of the West and the North, but also the process of criminalization and punishment constitutes its own form of violence as well. But anyway, that's not my question. So so Henry's asked Umar a question about I think norm creep and how some of these ideas seep through. I wrote it down half wrong probably, but how some of these ideas seep through, notwithstanding the efforts of the actors in the countries that you studied, Umar. But so this is a question, I mean, I suppose so to put that on the table, and then Henry, I'm really interested as well, and I think, and this is not just a question for you, but so for both of you, what counter-hegemonic moves look like and how they interact with kind of interdisciplinarity as a frame, right? So how far is interdisciplinarity, let's say, intimately bound up with counter-hegemonic moves in law and politics, right? Thinking of those together. So I think that's a question for both. And then, but for you, Henry, more concretely, like what would, Amet, this is not your project in the book, but you've alluded to this, which I wanted to ask anyway, which, like, what would the project of creating an explicitly counter-hegemonic archive, like what could that look like, and what would that involve?
So to get back briefly to Henry's question before I get to Heidi's, regarding norms of creep, you know, norms are always in a process of being negotiated and renegotiated, right? And they do evolve, and there are always the push and pull factors going on here. And the way I try to think about these norms and how states engage with the ICC, for instance, was through norms perversion. So the states that try to pervert the norms, and here perversion does not necessarily connote a negative sense. It's more so that states that try to creatively rethink the rules in ways that were not anticipated. Self-referrals would be one such example. But at the same time, the courts themselves also try to adapt to the new situation given the constraints within which they operate. One would see, for example, how the ICC is almost unable to prosecute state forces or even people who work within the state apparatus. And therefore, it has slowly devolved into focusing on quote unquote enemies of the state, because this is where it can get people arrested, this is where it can get people put on trial, this is where it can get people convicted. So then the court themselves try to find rooms for accommodation within the constraint that they operate with. That may not be true for all courts, of course, but my primary focus was on the ICC. And the track record shows that the ICC has been quite unable to prosecute state officials or even individuals within state armed forces. Therefore, the focus has been on rebels and or the enemies of the state. To the question of interdisciplinarity and what counter-hegemonic moves would look like, I think in the introduction, I remember if it was Henry or Heidi who said that the international criminal justice is in a crisis, which is interesting because, I mean, this is part of the DNA of the system, actually. It is in permanent crisis. Maybe that's also what, keeps it alive, the idea that if we do not do something to rescue this, it may collapse, and therefore it keeps people's attention. But at the same time, one of the reasons why it's always in crisis is that if we go back to the archives, if we go back to the history, like Henry is doing, we may see some seeds of this future crisis already. And one example would be that during the codification of the drafted code of crimes at the ILC in the 80s, early 90s, I found that African states had proposed a completely different system. They had a whole different vision of what the international legal system should look like. They had a whole different vision of what should be codified as international crimes. They proposed a list that had, I think, 16 or 17 different crimes to be codified. And in the end, only 4 was codified. And those 4 are the same ones that, become later part of the Rome Statute. One would think, why would African states want to have a longer list of crimes to be codified as international crimes? But because those were the ones who were of concern to them, unlike the 4 that has been deemed now to be of concern of the international community. African states wanted colonialism to be codified as an international crime, and this was in the 80s and 90s. They wanted mercenarism to be codified as an international crime. They wanted hazardous dump of hazardous waste to be codified as an international crime, because this was a big concern to these countries, and there was a strong pushback from Western states who vehemently oppose any discussion of codifying colonialism as an international crime, because that, were a self-serving position that Western states adopted. Then it is no surprising that, 20 years, 30 years later, we find the system to be in crisis, and African states to be very skeptical about this whole project, because what they wanted to see come out of this negotiation is not what ultimately came out of the ILC deliberations or the Rome Conference. I'll stop there.
So interesting to hear about that. I mean, I never knew that sort of counter proposal was ever made. So yeah, I'd be interested to see if you write anything more on that and to learn more about that. In terms of counter-hegemonic archives, that's a really good question. And there's a really good book, edited volume out, I think it was published 2 years ago by Isaac Kamola and Shiera Malak, who I was on a panel with at ISA with Benjamin Thorne in the audience as well. And that is the African anti-colonial archives in international relations, I think it's called. So it's a really good exploration of exactly what these counter-hegemonic archives will look like. And I think what you get from what I take from that volume is that they are of a materially different nature to the types of, I think, overtly hegemonic archives that we get from sites of law, which I think are in many respects the epitome of the archival drive, as Derrida writes about, this attempt to control every aspect of the way that knowledge is produced in a very coercive manner. But when we think about, so I think we can think about the idea of the counter-hegemonic in two ways. One is in the production of this archive, and then the second is in how it might now be played with subsequently. And in the former, I think what's important to say is that whilst this drive to control and constrain and exclude is at the heart of the way in which this archive is produced, it's never complete in this, it's never able to fully achieve this sort of level of control. And so we could look at the role of witnesses as disruptive figures in the ways in which knowledge is produced in these courts, that especially in the early trials of the ICTR, like against Jean-Paul Akiezu, the witnesses actually complicate the way in which the process and substance of law is practiced, right, and become active participants in the way that the archive is constructed, and in a way that I think pushes it back against some of law's desire to control and tame. So it's a neat process, but one in which it's not a neat process, sorry, and it's one in which changes over time. And this is again something we see where the ability that, in essence, the sort of legal drive and the legal force within the archive becomes stronger as the tribunal goes on, and the ability to disrupt and contest the logics on which the archive is produced become less and less with time. And then I think there's a question of what we can now do with this material in order to play with some of its boundaries and explore alternative ways of reading it, which open it up to new interpretation. And I would point to the work that of the artist that produced the front cover of the book, Vladimir Miladinovich, and the work that he does specifically with the ICTY's archive as a really good example of how another discipline here, the arts, can, I think, fundamentally work to put the logic of the archive, to reveal it for what it is, and then to open it up to other interpretations. And so Vladimir reproduces archival material in inkwash, which I think performatively, in reproducing the documents, draws attention to the dynamics that render that type of knowledge possible, what Rancière calls the distribution of the sensible. And then in encouraging different readings of it, undermines law's sort of obsession with finality, right? And rather encourages the viewer to think differently about the work, and rather than draw a full stop, ask a series of provocative questions, which engages the reader in actively reimagining what this archive can be. So I think we can either, when we're thinking about the counter-hegemonic, we can either think about what we can do with what's there and how we can play with the rules and logics that underpin these sites of knowledge production, or like the work of Isaac and others have done in IR, look at different sites of archives that function very differently and have very different effects.
Thanks so much, both. I think if we have time, I'd like to come back to this question of arts-based methods and your own research and pedagogy. But before we do that, we do have some questions coming in, so I'll allow the attendees to get engaged as well. So Benjamin, you've got a question. Go ahead.
Thank you very much, Heidi. Can you hear me okay?
We can.
So first, just to thank both of you for your really interesting summary presentations, and also your really engaging responses to Heidi's questions as well. I really enjoyed listening to those. And my question relates to one that Andy's written as well, which is more broadly around the idea of interdisciplinarity. And the question I'm going to ask you, I guess a caveat would be that I ask this as someone who myself kind of claims to be an interdisciplinary scholar, whatever that might mean. So the question I'm going to ask is something I'm very much thinking through myself. And so I think when we can all see how much interdisciplinarity has become a buzzword in terms of, I think Henry was saying at the very, or just before the roundtable started, about how funding calls has the buzzword of interdisciplinarity. You have to kind of talk about that in your funding proposals. Academic job adverts certainly have it as kind of a key word within job adverts, and also undergraduate and postgraduate degree programs in their kind of their web summaries of the courses often use the word interdisciplinarity. However, within its use, often what these courses or funding calls or job adverts mean is not necessarily interdisciplinarity. They mean maybe something else or something that combines that. And in one sense, we could say that interdisciplinarity has maybe become this kind of empty vessel that kind of sails all shiny and loud and sparkling, but kind of doesn't really have any substance. So my question is there a way we can put more substance back into this metaphorical vessel, or should we kind of abandon the vessel and look at other language, other approaches? And I know, Henry, I think Henry mentioned transdisciplinarity, or there's also post-disciplinarity or pre-disciplinarity. So is there something about the language and how the language itself around interdisciplinary research and teaching in international criminal justice has become a bit empty, and how do we maybe try and push back or move away from that, if that makes sense?
Shall I take a go answering that, or Umar, do you want to go first?
You go ahead, Henry.
Okay. Thanks, Ben, for your question. And I mean, I think the piece that you published recently, I can't remember which journal it's in, I think is an example of interdisciplinarity done in a meaningful way, because you've adopted a totally different way of presenting your work that is totally unfamiliar to the discipline of the journal that you were publishing, the human rights journal you were publishing in. So I think it is possible. I think my issue with some, including my own take on it from what I did for this book, is I think law is a bit distinct, because I think pure law operates in such has such a distinctive way of understanding the world that I do think bringing questions and perspectives from sociology, from politics, from history does open it up in a way that is meaningfully interdisciplinary. I think my issue with it being completely transformative comes that if, especially with my own, and maybe this is just my own failings as an interdisciplinary scholar, is that lots of the different approaches that I take from sociology or history or international relations have roots in very similar ways of thinking and approaching research. They could all be sort of traced back to, I guess, a European situated, post-structuralist minded approach to research. And that cuts across each of the perspectives that I bring to my reading of law. So that's where I'm hesitant to say that it's truly interdisciplinary, even though I do think that it does manage to ask questions of the law that a purely legal take on the court wouldn't be able to do. But I think that for me, the most meaningfully interdisciplinary work that I've done is when I've had conversations with academics that have been trained in a totally different approach to research and understanding the world that they live in. And that subject figure that I've had most encounters with is artists that have genuinely made me rethink lots of my own assumptions about my own work and lots of my approach to research and my approach to methods, and I would consider that dialogue between the two subjects trained in different disciplines to be meaningfully interdisciplinary and in a way that produces different ways of thinking, which is, I think, essentially what interdisciplinarity should be about, right? The world is too complicated to understand from any one discipline. We need to work out how to have these cross-disciplinary conversations, and for my mind, and I'm thinking about a research project I'm trying to imagine at the moment around thinking about the impact that arts-based projects have in post-conflict and non-post-conflict spaces, that for me, to make it a meaningfully interdisciplinary project would be about bringing together a combination of people that just have been trained so fundamentally differently that there's this slight disjuncture maybe at the start of a conversation, but that through working through the dialogue opens up these really new ways of thinking about very old problems. So I think it can be done. I'm not sure we need a new term for it. But I think you're absolutely right to bring caution to its overly frequent use, I would say.
Yeah, I agree with everything Henry said. And I'll just reiterate the fact that even though we may all seek more interdisciplinarity, it remains a fact that in the grander scheme of things, we have all been trained in a similar way at similar institutions using similar epistemologies. So therefore, it may be premature to view what we do as something that's being interdisciplinary enough, because there are other epistemologies that are out there that are still not part of this conversation, that we have not been trained to engage with or to hear. So there's room outside of this Western academia in which we all are embedded in. So there's still a lot of work to do in terms of interdisciplinarity. And this also ties to Andy's question about pedagogy and whether one must be disciplined first before being interdisciplinary. My understanding is that we are all, in this conversation from different countries, different places that may have different curricula. But where I'm in the US, at least, I think in terms of pedagogy and training, the fields are still very closeted. It is still very much disciplinary bound. The students, for instance, have very limited choices in terms of classes that they can take in order to get a specific degree, or they have to major in a discipline. And there is a list of courses that they must take, and then all the electives, of course. But in many ways, the training that we still provide is still within the bounds of the discipline. Now, there is good things about being disciplined into a discipline. Of course, we shouldn't just throw everything out. But once you are disciplined, or once you are trained into a discipline, which happens anyway, then there is also room to expand it and to reach out to other disciplines, or even to undiscipline, and bring more critical methods and pedagogies into the training that we provide in the classroom.
Thanks, Umar, for taking us to Andy's question, which is, so I'll just second the question for Henry as well around pedagogy. And I suppose, this is, I think many of us are, here for a reason. We've been thinking about kind of innovative pedagogical approaches, how to include approaches that we aren't necessarily ourselves trained in or are just starting to experiment with into our teaching practice as well. So that's my question, and also Andy's, I guess.
Yeah, so this is the question I was just trying to find in the chat, that do you have to be disciplined first before engaging in disciplinarity?
Yeah.
Yes and no. I mean, so part of my, as someone that was trained as a historian initially, I was trained in a discipline that was always very relatively unbounded with how it approached research, right? It was social history, drew on sociology, political history, drew on political science, cultural history, drew on anthropology. So it was all already a discipline that I think was open to that way of thinking, and something that I found really odd coming to an international relations perspective and international law was two disciplines that I know there are lots of us that engage in work that isn't this, but it felt very unaware of things that were happening elsewhere. And I think IR in particular has this very weird ability to pretend that it's invented stuff that other disciplines have been doing for decades, like the local turn or whatever it is. So do we need to be, I would say no, we should be engaged in understanding a discipline and its interrelation with other disciplines from the get-go. And so something that we're talking about with Heidi before the official talk started was I'm about to take some students to Kosovo to engage in a youth and arts workshop. And something that I'm really interested to understand there is how relearning lots of stuff they've already done from an IR and politics perspective around post-conflict work, youth activism and things like that are affected when they're put in a very different environment and a very different, engaged in learning in a very, very fundamentally different way. So I'll be really interested to see how exposing students that have already learnt something to a different disciplinary process, what that will do to their engagement and their understanding of these problems.
Wonderful, thank you both. All right, so we've got several interjections in the chat, which is great. So Eva, I hope I've got that correct. I'll just read Eva's question for both of you from the chat. So Eva says, I have a question for Henry, my fellow historian. How does the creation of the archive, as all the things you claim it to be, happen specifically? Having worked at some of these institutions, I think it's important to remember the archives are built as a byproduct and for the one and only purpose, which is to prosecute individuals for crime. I struggle to see some bigger master plan behind it because I've seen these institutions struggle with having any plan through the years and decades, let alone an elaborate one for archives, which no one cared about until 10 years ago. I really struggle with what seems to be the implication of a master plan to create an archive that does X. Thank you.
Yeah, thank you. That's a really good question. And there is no master plan. And actually, that these are a byproduct of other work is what I think makes them a valuable site to research, because the fact is that they exist and they contain an incredible amount of information. And by understanding the logics through which that information was pieced together and some of the unthought through aspects of it, I think we can learn a lot about these institutions. I would say that I do think that retrospectively, the argument has become more commonly said that these courts are just about delivering justice. But when you look at the early articulation of the court's mandates from key advocates like Richard Goldston, the first prosecutor, they were also very explicitly about doing more than that. And I think that when we look at the way that records are produced in the archive, for the archive, you can see traces of this, and then you can see traces of how things change when the emphasis on the courts changes and it becomes much more about just pumping out judgment after judgment, which I do think changes with slightly earlier than this, but there's a key shift with the introduction of the completion strategy. But there's no mastermind in any of this, and that I think that's the point about it, is that the way that, and this is drawing on Foucault, that the way that discourse and archives function is way more than any one individual. It's a product of unspoken, subconscious rules that dictate how knowledge is produced, and it's an understanding and those unconscious rules that we can understand the interrelationship between power and knowledge production. So no big master plan, but I still think that there's a lot to be learned from looking at the rules that underpinned the archive.
I just wanted to jump in really quickly, just on the previous question, if I may, about this sort of, do you need to be disciplined in order to engage in interdisciplinarity? Just because I very recently, about a year and a half ago, moved to Leiden University College, which is a liberal arts and sciences school, essentially. And one of the things that I've found really interesting about teaching there is that the students aren't disciplined from the get-go. They are, at the beginning, the very beginning of this education, they are engaging in multiple perspectives. Whether they're engaging in interdisciplinary perspectives, I don't know whether you can say that, but they're definitely engaging in multiple disciplinary perspectives. They do, as they go through their time, they do major in a particular area. So they could major in, for example, international justice. But even the students who are majoring in the major I'm part of, international justice, will be doing all kinds of, you know, world politics courses, economics courses, you know, on the side of that. And I think that's interesting. If, you know, if I compare my own education, which was, you know, very kind of traditional legal discipline education, I do think that that's an interesting route into the kind of pedagogical world, this liberal arts and sciences perspective. And it's something that I didn't actually know too much about until I sort of got this job. But I think there's a lot of value there, because they come to, for example, the law without having this, you know, long socialized processes to, you know, doctrinal law, black letter law, etc. They already come, when they first sort of touch law, they already come with these different ideas of politics, etc., introductory ideas. And I think it's interesting to think about where that may lead someone in terms of their thinking going forward. And I'm pretty interested to see, you know, how some of these students develop over the years, especially. But I just wanted to interject with that. This is a different kind of environment, I think. Thanks.
I feel like there'd be a really good research project to look at, because something that else I was thinking about with that question is, so I teach in the division of the School of Law and Social Sciences, but law is very much isolated from the rest of us within the school in terms of teaching. So criminology, sociology, law, politics, history, we all teach across each other's courses, and all of our students take courses in everyone else's disciplines except for law. And I think part of that issue is to do with that these degrees are accredited, and so they have to tick certain boxes in terms of how they're delivered. But I feel like there would be a really interesting project in tracing graduates that have gone through the two different legal trainings and seeing how they think about and practice law differently. And I wonder if that has any fundamental impact on, the way that they then pursue their careers. You would hope that there is, or else our claims to interdisciplinarity are maybe meaningless.
Thanks for that. There's another question in the chat from Maxine, which I'll read out to you both as well. Maxine says, I was wondering if either both panelists might be able to respond to something that has irked me as an IR scholar who dabbles in international law. Law often is developed retrospectively once it becomes clear there is a need to regulate something. Political activism or events are often the result of urgent needs or dissatisfaction and try to demonstrate areas where law could preempt needs. However, this often doesn't lead to changes in law, and it seems the legal profession continues to practice in this reactionary manner. I know that impartiality and neutrality are important principles in law, but how could legal practice in terms of law creation be more anticipatory? Is that appropriate for law?
I think this is a question for the lawyers about how you guys go about making law. But yeah, it's my sense also that law is typically reactionary as a response to challenges that are posed. And I think international law itself also faces much more challenges that domestic law would, in this sense, because you do have states and other actors who have very diverse interests and coming back and discussing and deciding how to put a law in place. One example of, like the crime of aggression has been in discussions a lot these past few weeks. And there's some sense that it was a missed opportunity, because had there been the crime of aggression that was much easier to prosecute than what it is right now, then maybe the other way of rectifying that, there are calls to create maybe a special tribunal that would have the powers to prosecute such crime of aggression. Again, this is another example of how a challenge is posed to the international community, and at least some actors try to figure out how to address it through international lawmaking. But again, I'm not a lawyer, so I don't know anything about these issues.
I would probably respond similarly, but I would, I think law is always slightly retrospective in this sense, and something that I found, again, as a non-lawyer, really peculiar is some of the retrospective justifications for some interpretations at the ICTR from the appeals courts in particular were, as a non-lawyer, just a bit, to be honest, totally baffling. But what I would say is that whilst, again, international courts are slightly different, as they're almost always brought in after a crime has occurred, although that's not strictly true, I guess. But whilst they are reactive in lots of respects, they are also incredibly creative. And so I don't think we should see it as being legal agents as being constrained to what the law is, right? They are incredibly correct when you look at how decisions are made at the ICTR or ICTY or ICC, the ways in which the law is reinterpreted constantly to make sense of different cases exudes in a huge amount of creativity and adaptability. So the law is never static in any of these situations. Whether or not it can be opened up in a more emancipatory, inclusive way, I think is something that I guess the ICC has attempted slightly to do with the introduction of victim parties, although not very successfully. I think one of the ways, and you pointed to it in the start of the question, one of law's issues here is the fact that it's obsessed with this idea that it is a neutral actor, it's an external actor to the political settings that it's involved in. And I think that obsession will always stop law from evolving as much as it could, because it stops it from acknowledging the fact that it means that it struggles to deal with the inherent biases that exist in the way that legal decisions are rendered, whether or not this is the role that race plays in sentencing practices or gender plays in how witness testimony is interpreted. I think the inability for law, because if it acknowledges that it's that all of these decisions involve a degree of politics, then the legitimacy of incarcerating individuals for violations of law becomes, I think, increasingly questionable. So that I understand why that there's a limit to how much it can acknowledge this, but I think until law can work out how to acknowledge its own failings more upfront, I think that any hope for a more inclusive, emancipatory form of the law will be lacking. But any lawyers in the chat, it would be, good to hear from you.
my own two cents, I'm not a panelist, but my own two cents as a lawyer, I mean, so, and this is something that Gary Simpson in his most recent book wrote about in one of the chapters about the constant claim within international criminal justice that what it's dealing with, like the constant turn to unprecedentedness as like a justificatory narrative, whereas, you know, and those of us who are working out of a more critical tradition that kind of reads all law is always already indeterminate. It's exactly as Umar and Henry have said, right? Are able to, I think, parse the political choices that go along with application and interpretation in different circumstances. And I think it's rarely true that there's such an absence of law that a given scenario kind of can't be dealt with. But there is a way in which international criminal justice puts that on the table in really stark terms. Yeah. So if there are any final questions from the group, do enter them in the chat or raise your Zoom hand. And I'll give you a bit of time to think through any questions if you have them. But I'll just, for my own part, ask, I guess, one final question, and it's deliberately meant to be quite open-ended for both of you. And so I'm interested broadly, I guess, in this question of relationships and relationship building and the role of interdisciplinarity and interdisciplinary work, both substantively, so like the work itself, the kinds of questions that can be asked, the ways in which those questions get answered, but also from a political economy perspective. So what the really, and this is something that's been alluded to, but if you want to talk more directly to it, what the relationship might be between the political economy of the profession and then our engagement with the concept of interdisciplinarity, but really like with each other, right? Because it seems to me that, you know, we can't, it's very difficult to, if not impossible, to do interdisciplinary work or interdisciplinarity alone. And kind of that might be part of the promise to this sort of work, and one of the ways in which we might be able ourselves to resist kind of the imperatives and pressures and constraints of the neoliberal academy, or etc. But yeah, I'd love to hear both of your thoughts on that very open-ended question.
I like that you mentioned the neoliberal academy, which we all are problematically part of. I think there is room to go beyond relationships among ourselves, who, to some different degrees, of course, are all privileged to do what we do, to engage in this work. So interdisciplinarity and relationships among ourselves are great to cultivate, and conversations such as these are very good spaces for such engagement. At the same time, I try at least to also be a bit more engaged with the communities that we study, those on whose experiences we try to draw our arguments and our theories and our writings, at least for those among us who do field work or who do engage with communities who are victimized by violence or who are affected by international lawmaking. There's a lot of more work to be done in that area, I think, and I try to do better and to be aware of the need to cultivate more ethical relationships with the communities that we study.
Yeah, really good question. I think following on from what Omar was saying, we can think of this in two ways. One is, I guess, academically, and as parts of an academic community that often a neoliberal system that forces or tries to force us to be individuals and excel individually. And I think I don't know if it's just the ECR early career researchers that I've been lucky to meet, but I think that there is a much more collaborative ethos now towards how research is approached, that is based partially on this interdisciplinarity, but also about solidarity and caring for each other in what can be quite a hostile environment a lot of the time. And then the second is what Umar was saying about thinking about the communities that we research, and that's I think something that turning towards participatory arts as method has been fundamentally about, is moving, anyone that's engaged with research sites like Rwanda or Bosnia know just how much awful research was done in these communities. Very extractive, very top down, externally imposed, little legacy left behind. And when I sort of started working with the arts and participatory methods, it struck me as a mode of operation which was fundamentally opposed to all of those dynamics. Not always, it can still be done badly, and often is done badly, or not done to its maximum. But I do think that, again, something that I do think is meaningfully interdisciplinary can forge much more positive relationships across disciplinary boundaries, but also across research boundaries, across the academy, NGO boundaries, across all of these different boundaries that we continue to constantly come up against it in our work. And I have seen I think the positive potential in this, both from producing meaningful research, but also to producing meaningful relationships and having at least a not negative impact on these communities, and hopefully a positive one.
Tremendous. Thank you so much. This has been a pleasure to be a part of this event and to listen to the conversation today. I think we're about ready to close. Barry, I'm going to hand it over to you for a final goodbye. But thanks once again for inviting me to be a part of it, and Henry and Umar for your writing and the discussion.
Thanks, Heidi, and thanks so much for sharing. It was really excellent. And thank you to the panelists, Umar, Henry. Really, really interesting conversation. So much to think about and reflect on further. And I think, these are the kinds of conversations that are really important if, we do want to see interdisciplinary research. And I think that last question, Heidi, about relationships is really key to this kind of research, and the different sort of types of relationship as well, to think about those and how they can be brought forward. So thank you everyone also for attending, very much appreciated. And I guess I'll just close with a reminder that we do have the ESIL IG does have a call for abstracts open at the moment for the annual event. So please take a look at that if it might be of interest to you. Otherwise, I'll leave it there and say thank you very much, everyone. Thank you.